I am live. It is almost 3:30, Sunday. I'm about to start chapter 16. Chapter 16, Pre-Trial Summer of 1997. Oh my God, this book. This book is wild, like completely wild. Okay, I switched to just water. I do not need any more tea, any more coffee. I do not. I just need to hydrate because this book is all the things. We are reading Margot Nash, The Politics of Murder. Before I get going, I would like to say I am about to start chapter 16. If you're just hopping on, please don't just start from chapter 16. Everything prior to chapter 16 I have uploaded. It is in my Politics of Murder playlist. Everything prior to this is uploaded and ready to listen. Go up, put on your earbuds, kick back, do some cleaning, do whatever you can do around the house, and listen. I've read everything up until this point. And then come back and come to here, and then keep going. Don't miss a second of this book. Good Lord, don't miss a second of this book. It's crazy pants. All right, we are now pre-trial summer of 1997. After Judge Timothy Gailey's decision of May 9th, 1997, sent Eddie O'Brien to Superior Court to be tried as an adult, he appeared for his arraignment there. Murder cases in Superior Court in Middlesex County can take up to 2 or 3 years to come to trial. Wow. The average time is 2 years. That's crazy. Eddie, fix the pillow. Here we go, that's better. Eddie's trial date was set for September 19th, 1997, just 4 months away. Eddie's lawyer, Bob George, still think that name is crazy. 2 first names as a whole name, Bob George. I don't know this, I can't. Eddie's lawyer, Bob George, filed 2 motions at arraignment. The first was for a stay of the proceedings so that he could appeal Gailey's transfer decision. That was denied on the grounds that such a request needed to be filed in the Supreme Judicial Court along with the appeal of Gailey's decision. George had not filed any notice of appeal or request for a stay in the higher court. He also did not do so for Eddie's arraignment. The second motion requested a continuance of the trial date because 4 months would be insufficient time to prepare for a murder trial of this magnitude. George said he just could not be ready by then. He was right. Riley, however, had no time to waste. If he was going to run for Attorney General, politics. If he was going to run for Attorney General in the 1998 elections, he had to announce and begin campaigning in the fall of 1997. Time was of the essence. Slime. He was pushing for an immediate trial. George's request for more time to prepare was denied. The judge said that the case had been pending for 2 years already. Technically, that was untrue. A case doesn't start pending until the defendant is arraigned in Superior Court, which had only happened that day. So began a series of pretrial hearings and motions, some procedural and substantive. The purpose of pretrial hearings is to determine whether the parties have exchanged discovery information appropriately, whether there are any agreed upon exhibits that will be entered into evidence at trial, and to settle any disputes about the required exchange of information and documents. It is also the time to request that certain evidence be excluded at trial or to argue for the inclusion of disputed evidence. George was a well-known defense lawyer in Boston. He had his own 2-person firm and hired other attorneys when needed for trial. When he came onto Eddie's case in November of 1995, he requested a fee of $65,000 to litigate the case. Can you imagine? That price soon went up to $85,000. Over the course of the next 2 years, the O'Briens paid him a total of $150,000. After 2 protracted transfer hearings and 4 appeals in the Supreme Judicial Court, George told Eddie's parents he was out of money in the summer of 1997 and asked for an additional $150,000. What the hell are you doing with the money, dude? Smoking it? My words, not the book. They didn't have any more money. Of course they didn't. You think it grows on trees in the backyard, dude? What the fuck? Eddie's mother was caring for 4 kids at home, the youngest of whom was 2 years old. And working in food service for Tufts University part-time, Ed worked as the manager of a mail and receiving services at Harvard University. Their incomes were very modest. They had already mortgaged the family home. Are you kidding me? There was just no more money to be had. No doubt George's original fee was long gone by this time. The case had consumed almost 2 years of constant work. Well, a lot of good it did Eddie. I'm so disgusted with my state. Beyond disgusted. Crappachusetts. I'm going to start calling it Crappachusetts. Estimating what a criminal case will cost to defend is very difficult. These cases are not done on an hourly fee basis. Excuse me. Pardon me for a moment. Water. The beverage of the gods. Here we go. These cases are not done on an hourly fee basis where the client pays for the time expended. Rather, they're done on a flat fee basis, a sum that will sometimes but not often include the cost of expert witnesses, independent testing for the evidence. Of the evidence, George's quoted fee included all experts and testing. In this particular case, not even a more seasoned defense counsel could have predicted that he or she would spend 2 years litigating the case in the juvenile court alone and make 4 separate trips to the Supreme Judicial Court before even getting to the murder trial. It is unfortunately not uncommon in the legal business for an attorney to underestimate a fee and to be working for free by the end of the case. Rank-and-file defense counsel are rarely wealthy. It is possible to lose hundreds of thousands of dollars on a case that you have not even priced outright. Big law firms have the ability to absorb such losses. Smaller practitioners like Bob George do not. Lack of money may be the reason why none of the experts that George discussed with Eddie over the prior 2 years had been contacted, let alone hired. Or perhaps George had believed that the case would remain in juvenile court and that Eddie would, even if found guilty, be freed after serving his 21-year sentence. Whatever the reason for not having expert witnesses on board, there was no way he was going to hire them now with no money left and prepare them for trial with no time. Forensic experts on the necessary notoriety would have required a financial retainer for months before their expected appearance. They would have required access to the documents and evidence they would be rendering opinions on months before. If they were to do independent testing, specimens would need to have been sent weeks before or months in advance. Nevertheless, when reporter Ann Donlan of the Boston Herald asked Bob George how he would explain the forensic evidence at trial, he told her, "We have not yet tested the blood. We have not yet tested the blood." If I was Eddie's parents, after having given him that much money and hearing a response like that, I'd have taken out my biggest wooden spoon. Dude. Would not have been pretty. I can't. I cannot. Oh, you know we're pulling out the pops. I cannot. I cannot. Oh, we're going with the grape. I need a grape. I can't be reading all this garbage without a pop. We have not tested the blood yet. 2 years. I spent all the money. But no, I didn't actually test the blood. Want to come over for some cheesecake? Yeah. We'll just shoot the shit in the yard. I got nothing to do. We're not testing blood. Just spending your money. I am not a lawyer. I do not profess to be a lawyer. I have spent my lifetime being a professional nanny for over 35 years. I have been a hairdresser. I have been many things. A lawyer is not one of them. I know nothing about how any of this works, but I do know if I mortgage my house twice to pay for legal counsel, and that legal counsel doesn't even manage to test blood to defend my child, shit's going down. I will get the biggest wooden spoon in my kitchen and go Italian and take her things old school. That's just me. I can't. We have not yet tested the blood. We have our own experts that will take a look at the blood. When? In 2097, when everyone's dead. Awesome. That I ad-libbed that. It's my snarkiness coming through, because they didn't do it. We have not yet tested the blood. We have our own experts that will take a look at the blood. If you read this book and you're young, it'll hit totally different. You read this book in your 50s and you're a mother or a grandmother. I'm just a mom, no grandkid yet. I only have a 21-year-old. But I'm reading this from the viewpoint of a mother. If this had been my child and this is happening and I mortgaged the house twice to try to pay for legal counsel and legal counsel responds to the Boston Globe, we have not yet tested the blood. We have our own experts, but they'll take a look at the blood, but they haven't done it yet. Oh, you haven't done it yet? I mortgaged my house a couple times for you. You get all my money. I got the houses. Bank's going to take the house, but you haven't done it yet? No. Take your time. It's fine. I'm going to go make some ramen for dinner. You take, no, don't even sweat it. Don't. You're good. It's all good, dude. We're fine. Eventually we'll be in a tent in the neighbor's yard, but don't sweat it. Take your fucking time. During the many pretrial hearings conducted that summer, the judges, there were several, ruled to exclude certain evidence. Well, why not? Why not? Let's exclude it. We don't even have the blood evidence. Let's just exclude other shit. Eddie's sodium amytal test was out. That is truth serum. Profiler Greg McCreary's testimony was also out. Blood evidence would be critical. The science of DNA was in its infancy in 1997. In Massachusetts, DNA evidence was not automatically admissible into evidence. A lengthy foundation which met exact criteria had to first be established in order for an expert to testify as to DNA findings. This was back in the day. It was a Wednesday, back in the day. It's so different than it is now, people. I lived through this. You guys have no idea. So different back then. Now, you can't get away with jack shit now. DNA, they're gonna find you. Karma always collects her debts. But thankfully, now, even years later, karma always finds, the truth always finds the sunlight now. It may take 30 years, but they're going to find out. DNA. The science of DNA was in its infancy. But just 3 weeks before Eddie's trial began, the Supreme Judicial Court issued a ruling making DNA evidence admissible at trial without this tedious foundation being established first. The court found that Cellmark Diagnostics' specific tests and the population calculations that were used to compare results were scientifically reliable. Any future DNA evidence using these tests and this calculation would automatically be admissible into evidence. Eddie's DNA had been tested at Cellmark Diagnostics. The tests and calculations used were identical to the ones in the new ruling. His DNA evidence would now come into evidence as a matter of law. Eddie's DNA had been identified in 4 places at the Downing home. Well, hello, he hung out there. He was friends with the kids. That's like saying, we found your DNA, Amy, all over your bedroom. Well, no shit, Sherlock. I sleep here. It's my room. That's the stupidest thing I ever heard. The inside of the foyer or inner front post, the dining room door jamb, the cellar post, and a dress hanging on a clothesline in the basement. Makes perfect sense. That's the trail he took when he went into the house, saw her, said what he did, and then exited through the basement. This should not be rocket science. Prior to his development in case law, Eddie's lawyer could have challenged the introduction of the DNA evidence as scientifically unreliable. Had he been successful, the only evidence the DA would have had to rely on would be the fingerprint and the hilt of a knife that the DA alleged was the murder weapon. That may not have been sufficient for a conviction, especially where motive and opportunity presented such enormous problems. Because the DNA was now clearly coming into evidence, Eddie's statement about finding Downing and confronting her attacker would absolutely be required to explain his presence at the scene to the jury. Some of the evidence in dispute included the alleged statements that Eddie made, primarily to his best friend Ryan Downing, which according to the DA showed his motive to murder Janet Downing. Riley argued to allow these otherwise inadmissible hearsay statements, although the Commonwealth, in the course of its presentation of evidence, will be able to offer physical and other evidence which directly connects the defendant to this crime. What the Commonwealth will not be able to do with that evidence is explain why this happened, why the defendant killed his neighbor, questions of motive, questions of intent, questions of or issues of state of mind. The Commonwealth's theory of this case is that this is not a case that is without a context. It is not a case where there is a totally unexplained act of violence. Our theory of the case, Your Honor, theory, is that there was an escalating pattern of behavior on the part of the defendant, Edward O'Brien. If the DA had been hoping for a sweeping order allowing all these allegations, incriminating statements to be heard by the jury, he was resoundingly defeated. The court ruled that each and every one of the acts or statements that the Commonwealth sought to introduce into evidence would require a separate and distinct inquiry as to why it was being offered and whether it was admissible under an exemption. Oh, my light just went off. That's fun. You can still see me. We're good. Whether it was admissible under an exemption to the hearsay rule, and if admissible, whether it was actually relevant. This is the proper standard by which such evidence is evaluated by the court. Riley would have had to fight to get each one of these statements into evidence, and he had already lost some of those fights during the transfer hearings. It's insane. In another hearing in July, George asked that any unidentified fingerprints lifted at the crime scene be provided to him for comparison. Assistant DA Tom Riley, who was filling in while DA Tom Riley was on medical leave. I gotta read that again. Assistant DA Tom O'Reilly, who was filling in while DA Tom Riley, these names are also similar, good Lord, was on medical leave, stated that no other fingerprints except those belonging to Eddie O'Brien were lifted from the scene. That's a lie. I've been reading this book. It wasn't just his. That's a lie. Oh my God, my state is so corrupt. My state is so corrupt. It makes me sick to my stomach. Here we go. That assertion was untrue, or what people around here like to call a false memory. A report from the State Crime Lab, dated and received after this hearing, listed 7 additional latent prints lifted from the scene, 3 of which were identifiable but were not Eddie O'Brien's. The other 4 had insufficient detail for an identification to be made. The denial that any other prints existed and subsequent failure of the DA to hand over these prints for defense analysis are serious breaches of court discovery rules, as the prints were potentially exculpatory. Exculpatory evidence is evidence favorable to the defendant that exonerates or tends to exonerate the defendant of guilt. It's just making me angry. All of this is making me angry. Bob George either failed to see the breach or ignored it. He didn't inform the court that the other prints existed or file a motion to compel the DA to turn over that evidence. He failed, dude. This dude failed 3 days from Thursday. Those fingerprints remain unidentified. One of them was lifted from the hallway bathroom where the killer washed up and left the water running. That would have been a very important print to run through the Integrated Automated Fingerprint Identification System, IAFIS, to see if a match came up. I would think so. I don't know. I don't do that work, but I would think maybe. It seems logical. Assistant DA O'Reilly further informed the court on July 27, 1995, that evidence had been sent out on July 15, 1997, for DNA testing, and that the results were not expected back for another 4 to 5 weeks. Yet another false statement. More false memories. The only DNA testing not complete at that time was on the metal piece, item number 21, the hilt of the knife, and Janet Downing's bloody fingernail clippings. The fingernail clippings had already been sent out for testing a month earlier, but testing had been suspended until further notice? Who the hell stops that? You're trying to find out who killed this woman. Why would you suspend the testing? The letter of transmittal dated June 27, 1997, accompanying the fingernail clippings said, and I quote, "Please hold the enclosed blood-stained fingernail clippings from Janet Downing until you receive authorization from DA Tom Riley, ... Upon authorization, please conduct PCR, STR testing on these specimens," end quote. The knife hilt had been sent to Cellmark Diagnostics in Maryland a year earlier. Initial PCR testing on that showed no trace of Eddie's DNA. Why would the prosecution try to obfuscate the fact that this evidence was not sent out on July 15, 1997? Laboratory reports would eventually reveal the truth. It didn't make any sense unless the prosecution assumed that their hold and discontinue testing orders would not be included in the letters between the state lab and Cellmark Diagnostics, or the final reports from Cellmark Diagnostics. Studying these letters and reports took a considerable amount of time, especially to connect the dots and clearly see the misrepresentations made to the court. When you receive completed DNA and scientific reports right before a trial, the chances that you are noticing the dates that specimens are submitted and dates that they are tested and cross-referencing that information with the correspondence file are slim to none. Unless, of course, you suspect something unusual has occurred with the evidence. In Massachusetts? Go on. In Eddie's case, all of the evidence was highly unusual and questionable, and required the kind of in-depth effort that has now brought these irregularities into full view. The pretrial hearings took place on 8 separate days over the course of the summer, ending on September 8th, 1997, just 7 days before jury selection would begin. Bob George didn't have months to spend scrutinizing discovery material. He barely had time to draw an opening statement. I don't even know what to say. It's like the state of Massachusetts is being run by clowns. Being run by clowns. In the judicial system, in the police system, it's so disheartening. And it's still happening. It's still just as disgusting. Nothing has changed. The only thing that changes around here is the date on the calendar. That's it. Chapter 17, jury empanelment. This should be fun. Let's see what kind of fellas and ladies they got for this jury. The trial began at 9 a.m. on Monday, September 15th, 1997. Jury empanelment took most of the first 3 days. Several hundred jurors were summoned to court, divided into panels of 18. After the judge posed preliminary questions to the entire jury pool, the panels were brought into the courtroom one at a time. Each person in that panel was then asked specific questions about the case they would hear if chosen as jurors. If the judge found that the juror harbored no bias and could serve for the duration of the trial without imposing undue hardship, he declared that the juror stood indifferent. The Commonwealth and the defense attorneys then express that they are content with that juror, or they challenge the juror and seek removal of that person from the jury. In a jury where 16 jurors are seated, leg hurts. Here we go. Have to shift sometimes. Let's see if I turn this like this. Here we go. In a jury where 16 jurors are seated, 12 jurors and 4 alternate jurors. Each side can challenge up to 16 potential jurors who have been found to stand indifferent without stating the reason for their challenge. Maybe you didn't like their socks. Who knows? You don't know. It's Corruptachusetts. Anything goes here. Those jurors so challenged are immediately excused from service. These are called preemptory challenges. Apparently they're never told why. They're just said, bye-bye, exit stage left. In addition, either side can challenge jurors for cause, but must disclose what the reason or cause is. Jurors challenged for cause are not necessarily excused from serving. They usually do feel resentment towards the lawyer who challenged them, so cause jurors are often argued at sidebar. Sidebar! Somebody's got to open up a place around here called sidebar. For real. It needs to happen. At this point, it needs to happen. It needs to happen. They usually do feel resentment toward the lawyer who challenged them, so cause challenges are often argued at sidebar outside the hearing of the juror. At the conclusion of the jury empanelment in this case, 226 potential jurors were questioned. 208 were excused, and 16 were seated. Wow. Bob George, still a weird name, used 15 of his preemptory challenges, and D.A. Tom Riley used 13. Of the 208 excused jurors, 76 were excused because they said they had already formed an opinion had already formed an opinion that Eddie O'Brien was guilty based on media coverage. That is ridiculous. I mean, I get why it happens, but it's still ridiculous. Excuse me. Only one person said she had seen no media coverage of the case at all, and just one person said she believed that Eddie was innocent after reading and hearing about the case. God bless her. Eddie's case was sensational. Excuse me? And the coverage, and its coverage was exacerbating by the non-stop political posturing surrounding it. Every single chance in the juvenile justice law occurring in the 1990s in Massachusetts was the result of a specific and horrific murder. It was legislation by fiat, not thoughtful discussion. I remember that. I graduated in 1990. This is like going back. It's like a time machine, a horrific time machine, dragging me back to a time that I would like to stay here. You don't go backwards, you go forward. Commencing in 1994, an entirely new juvenile court system was created, separate and apart from the existing trial courts, and a score of new judges were appointed to preside over those courts, whereas Heffernan and Gailey were district court judges who presided over juvenile sessions periodically. The new juvenile court judges did nothing but hear juvenile cases. All this reorganization and expansion was in anticipation of the feared wave of juvenile super predators, babies, 13, 14, 15. Come on. I get it, some of them are cut from a different cloth. I understand this. However, come on. All of this reorganization and expansion was in anticipation of the feared wave of juvenile super predators that never materialized as pundits predicted. Lived through it. Didn't happen. There's little doubt that all the media exposure that was generated had tainted the jury. Sorry. Yeah. Sorry, I'm seeing all the corruptions floating around all my room. It's probably outside the house too, but you know. It's all over, it's everywhere. It's Massachusetts, it's what happens. It's just insane. Should Eddie's lawyer have renewed his motion for change of venue after 1 in 3 jurors had to be dismissed due to pretrial publicity, it is highly unlikely that once 16 jurors were found to stand indifferent, the judge would have granted such a motion. However, in order to preserve an issue for a later appeal, a lawyer must make the motion and the judge must deny the motion. George never did, and the O'Brien jury was sworn in and seated shortly after noontime on Wednesday, September 17th, 1995. You bastard. The district attorney took one more run at getting the judge to allow him, to reference the statements Eddie allegedly made to Ryan Downing so he could use them in his opening. Riley reiterated to the judge during a lobby conference, a meeting taking place in the judge's private office, that the statements gave a context to the crime. George pointed out that they gave motive to the crime, not context, and that the prosecution was not required to prove motive. Judge James McDaniel relented and allowed the district attorney to refer to 4 statements in his opening. The judge said he would give the usual admonition given to all juries that opening statements are not evidence. They are what the prosecution or the defendant hope to prove at trial. The only proper evidence that the jury may consider is what is actually said by a witness under oath. The jury admonition is a powerful instruction, But opening statements can be very persuasive. It is very hard for a juror to disregard a statement that has made an impression on them or had a ring of truth to it. The jury was escorted to a bus at 12:30 p.m. and taken to Boston Street to see the scene of the crime, the Downing home at number 71. They would also view the Reckley house at number 73, Eddie O'Brien's house at number 74, and the Midnight Convenience Store. This process is referred to as taking the jury on a view. During a view, the lawyers point out certain areas or features and tell the jurors to take note of them because these places or things will come up during the trial. The judge rarely speaks. The lawyers are not permitted to say how or why these areas, places, or things are important, just that they want the jury to remember where the windows are. For example, the jurors are escorted by 2 jury bailiffs who carry large staffs to indicate that this is a working jury. No, no one except the lawyers is permitted to speak with the jury while they are working. The view took most of the afternoon, and the jurors returned at 3 to cold pizza. Now, see, cold pizza is different to me. Cold pizza, to us Gen Xers, means something completely different than actual cold pizza. That's a different life for a different day. Here we go. The jurors returned at 3 o'clock to cold pizza that had been awaiting them since the 1 o'clock lunch hour. At 4 o'clock, the judge assembled everyone in the courtroom to announce that opening statements would be deferred to the following day, Thursday at 9 a.m. That's just crazy. My cold pizza was better than that cold pizza. Chapter 18, The Rules of the Game. How do 12 people who have little or no knowledge of a complicated legal proceeding make sense of all these new words and expressions they are hearing for the first time? How indeed? How indeed? How do they know what it means when a judge says sustained or overruled? The truth is that often they have no clue. They don't understand. It is daunting and stressful to be a juror. Judge McDaniel always spent the first part of a jury trial instructing the jurors on what to expect in the coming days and weeks. He defined some of the jargon and formalities required of a trial so that the jurors might feel better equipped to listen to the evidence in an impartial way. I call bullshit. The only evidence in this trial, he told the O'Brien jury, will be the sworn testimony of the witness who testify and any exhibits that are marked into evidence during the course of the trial, and of course, any inferences that can be drawn from the evidence. And on that basis, and that basis alone, you determine whether the defendant is guilty or not guilty. It is strictly your memory that governs as to what the evidence and testimony is in this case. When an objection is made, then it is incumbent upon me to rule on that objection. If I say the objection is sustained, that means the witness may not answer the question, and you are not to consider that question at all. It is as if the question were never asked. You are not to speculate as to what the answer of the question might have been. Of course, if I say the objection is overruled, that means that the witness may answer the question, and then the answer and the question go to you for your consideration. Now, sometimes during the question and answer process, lawyers are permitted, especially on cross-examination, to ask what are called leading questions. And a leading question is simply a question that is couched or phrased in such a way that it may suggest the answer to the witness that the lawyer is looking for. A no answer to a leading question is not evidence for your consideration. It is only if the answer is yes or affirmed in some way that you may consider it evidence. Any words from my mouth indicating to you that you are not to consider that evidence, you are to do so exactly that. You are not to consider that evidence thereafter. You may say to yourself, well, I have heard the question, I have heard the answer, and I like it. I'm going to use that later. You are not permitted to do that. In fact, the jurors were not permitted to take notes. What? Since when are jurors not permitted to take notes? I do. This whole thing is asinine. The jurors are not permitted to take notes, and the chances that they'd remember everything the judge had said over the next 11 days were slender. How about non-existent? After his remarks, the judge told the jury that at the end of all the testimony and the takings of the evidence, their names would be put into a basket and 4 names would be extracted. Those 4 people would become the alternate jurors, and the other 12 would become the deliberating jury. He instructed jurors to listen to all the evidence because no one knew who the alternates would be until the end, and then the trial began. Now, I need to pause. Chapter 19. I'm pausing at opening statements. I need a minute. I can't. I shall return with chapter 19. I just need a few. Okay? This book is cray-cray. I need a minute.